Hey class, how are you? So this lecture is going to be on the materials we have that's in our April 2nd, 2020 folder, Post-Conflict Justice. And I wanted to talk first about the first article by Catherine MacKinnon. We have had her writings in our class before. This was a particularly important article that she wrote about one of the most monumental decisions at the International Criminal Tribunal in Rwanda. So, um, just to briefly give you an overview about international tribunals, uh, the two most notable ones that were created after conflict were the ones for the Rwandan genocide and the one for the wars in the former Yugoslavia. From 1992 through 1995 that covered. So the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda were called ad hoc international tribunals. And the main purpose of these tribunals was to prosecute the big fish, so to speak, the organizers, planners, and perpetrators of war crimes, crimes against humanity, and in some cases genocide in each of these contexts. So these were very important with regard to articulating some really important stuff with regard to war crimes, crimes against humanity, and genocide, particularly with regard to crimes of sexualized violence during conflict. And this is what we're focusing on. In your additional materials folder on Blackboard, you're going to see links to three um, tribunal trials. One from Rwanda, prosecutor versus Jean-Paul Akayesu, and two from the former Yugoslavia, which were very important with regard to um, outlining the crimes of rape as genocide, rape as a crime against humanity, things like that. So I offer those links for you to look at. These three were going to be particularly important for MacKinnon's article. So I wanted to show you links with regard to those those trials themselves. So with regard to MacKinnon's article, she begins the article kind of outlining differences between in a trial, particularly definitions of rape, and particularly with regard to definitions based on coercion, definitions based on non-consent. So when we think about consent-based definitions, this centers on the idea of, like, say, love or passion going wrong, as she explains. So it is what is important to inquire about with regard to criminality is the mental state of the perpetrator and the mental state of the victim. Who wanted what, who consented to what, who knew what was going to happen, etc. So these definitions tend to frame sexualized violence and rape during conflict in particular as like one at a time interactions, and important to understand who consented to what, right? So this gives a different kind of onus on the perpetrator, different kind of onus on the victim. With regard to coercion definitions of rape, they center on how rape is coercion definitions see power, domination, and violence as a particularly important factor. So it is important to understand the surrounding context. In a situation such as genocide, armed conflict, coercion definitions really talk about the exploitation of the relative position of the actors, the perpetrator and the victim, right? Who did what to whom, why, and these are very contextual, very important to understand the context of it. Wherein what was important with regard to the criminal tribunal in the Rwanda with regard to the Akayesu decision, it held that rape charged as a crime against humanity is a physical invasion of a sexual nature committed on a person under circumstances which are coercive. So it was very important to understand the context that the whole situation was coercive. this has very important implications with regard to charging rape as a crime against humanity, a war crime, and a crime of genocide. So the Akayesu trial chamber went on to define an act of coercion. And I want to read some quotes from the decision. One quote says that the chamber considers that rape is a form of aggression and that the central elements of rape cannot be captured in the mechanical description of objects and body parts. And so let's think of ourselves, what does that mean? It's not just about this person inserted this thing into the other person's sort of kind of thing, right? It has to We have to understand that rape is just more than that in this sort of context of war and genocide. It goes on to say in this decision that, quote, coercive circumstances need not be evidenced by a show of physical force, but, quote, can be inherent in circumstances like armed conflict or military presence of threatening forces on an ethnic basis. So this was crucial with regard to charging Jean-Paul Akayesu with the crime of rape. As a crime against humanity, war crime, and genocide. So super, super important. So what does this all mean, right? These quotes and everything I've said so far. Basically, what the trial chamber in the Akayesu case found that in the context of crimes against humanity or a genocidal campaign, such as what happened in Rwanda against Tutsi, inquiry into individual consent, who consented to what, is really a meaningless question because the whole situation was coercive. So that was a very important outcome of the Akayesu decision, right? So with regard to Jean-Paul Akayesu, he was a mayor of the Taba commune in Rwanda. He was found individually criminally responsible for crimes against humanity, such as ordering, instigating, and abetting the sexualized violence that took place in his commune or province, if you will, his neighborhood. So he was found individually criminally responsible for ordering and instigating, abetting, and aiding into the sexualized violence that took place. And also, in this decision, sexualized violence was charged as genocide for causing serious bodily or mental harm when committed as part of an intentional campaign to destroy a group in whole or in part. So Akayesu was found criminally responsible for genocide as well. So this decision articulated rape as a form of genocide, right? So this was a very important decision with regard to coercion-based definitions with regard to rape on the international level. However, there were some later decisions at tribunal, particularly in the former Yugoslavia tribunal, which were some very important decisions. The Ferendizia decision was very important. With regard to MacKinnon's analysis, what we start to see is consent-based definitions creeping back into the rationale in the trial and charging it in the decision itself. One particular case that was important was the Tadic case at the International Criminal Tribunal in the former Yugoslavia. This case established many parameters with regard to the legitimacy of the tribunal process itself on the international level. This trial dealt with the Omarska camp in Bosnia, which was a site of horrific sexualized violence against both women and men. But in this case, it was a problematic case because it changed one of the rules to not allow consent as a defense to not being allowed to rule it out entirely. So that way, it could be argued on a consent-based, even though it was in the context of genocide, it could be argued by the defense that we need to prove consent, which is problematic, right? Particularly in the context of war and genocide, where really questions of consent are meaningless, according to Captain MacKinnon. So it was clear that the trial court in the Akayesu case in Rwanda really got it right with regard to rape as genocide and how consent-based definitions make no sense. The ICTY record is somewhat disappointing, somewhat mixed in that respect. There's a link on Blackboard in our additional folder with regard to Kunarach's case. This was a trial of three high-ranking soldiers in that centered on the Foča rape camp in Bosnia. They talked about, they did very important work because this was a very important case which charged sexualized violence as a crime against humanity, particularly sexual slavery, right? But it was problematic in some respects, as you'll see from MacKinnon's analysis, as to how they strayed away from coercion-based definitions, right? The same thing we see later in some later trials in the International Criminal Tribunal for Rwanda, particularly in the Samansa decision, which said that defining rape simply through a mechanical description of objects and body parts was too broad. Like not defining it as simply through a mechanical description of body parts was too broad. So they adopted kind of like the standard of the ICTY. And so kind of reverting back to a consent-based standard, which is problematic. So So you'll read that. These are the main points from MacKinnon's article with regard to some of these international criminal tribunals. And I also invite you to look at the links in our additional folders material with regard to some of the major cases that charged sexualized violence as a crime of humanity, war crime, or genocide, as the case may be. So very super important. All in all, international tribunals were, particularly in the beginning, some of the only ways in which survivors could receive justice with regard to the crimes committed against them. Since then, things have expanded in the local context on the state level with regard to trial on the national level in Rwanda and the former Yugoslavia, and etc. So all very important, but so the tribunal, from under MacKinnon's perspective, has a mixed record, highlighting the importance with regard to Akayesu charging rape as a crime of genocide. Very super important. So important to understand her, what she's talking about in this. And I will going to leave my lecture now. I just want to give you an overview of her article. I will do my next video on Julie Murtis's article. And thank you very much, and see you in a minute.